Good evening, everyone. We'll start with the webinar. I welcome you all for the webinar on the Supreme Court order on the payment of wages. Few points to remember, housekeeping points. I'll just share my screen. Everyone, all the participants are on mute except for the speakers. We strongly advise you not to open links on the chat box. Chat box is for any points to be raised if the speaker's voice is not clear, or you can ask questions. But we recommend you to ask questions on the question answer box that is on the bottom of your Zoom screen. And we highly appreciate you to ask as many questions as possible, and speakers will take up all the questions at the end of the webinar. We'll have last 15 to 20 minutes to answer all the questions. The webinar is recorded and is also available on the YouTube channel after the webinar is done. I like to hand over it to the Executive Director of the Swiss Indian Chamber of Commerce, India, Shiv Prasad Lal. Over to you, Shiv Prasad.
Thank you, Mahik. I welcome you all on behalf of the Swiss Indian Chamber of Commerce, the Swiss Business Hub India, and the European Group Federation. Today we have Colonel Chandok, who is the Managing Director of the famous Swiss company, or rather the company famous for knives and for watches and travel kit. So he's also the President of the West chapter of the Swiss Indian Chamber of Commerce. Colonel Chandok, I will hand over the knife to you for cutting the ribbon and with your opening remarks. Colonel, I think you're on mute.
My apologies. I took the first instruction page very seriously. Thank you, Shiv Prasad. A very good evening, dear members. A very good evening to our esteemed and respected panel. I hope you and your families are all safe and adapting to the new normal, as we all call it nowadays. I think it's by far the coolest term to address the situation that we are in. In these challenging times when we are all working from home, we at the Swiss Indian Chamber of Commerce are trying our best to organize knowledge sharing sessions for the benefit of our members and their teams. Today we have 12 such webinars, and this time we are very happy to have the team from Legasis headed by Mr. Suhas Tulyapurkar take this initiative and get this respected, bright panel to discuss on a very important topic, which is the recent Supreme Court order on payment of wages. A topic which, irrespective of the size of the organization, has been a hot topic because the cost of the human resource is one of the largest costs on a P&L of any organization. And what has worried all the leaders and the entire business community all throughout has been to strike a balance between the social objectives plus also the legal take. And this new order is something we eagerly look forward to hear on. Let me now introduce the eminent speakers for today. Mr. Suhas Tulyapurkar is a name that doesn't need a big introduction paragraph. A big name in the legal fraternity of India. He is the managing partner of Legasis Partners and founder director of Legasis Services Private Limited. He is a practicing lawyer with almost 4 decades of experience, including as a corporate lawyer in various companies before starting his practice, and has some very big names up his sleeve, cases where he's brought legal success to his client companies. He's one of the leading lawyers in the field of corporate governance, compliance and ethics, and legal strategies. He is also a certified independent director, a certified compliance and ethics professional, and an accredited mediator and conciliator.
You're a good friend, Colonel.
No, I would have been good if I would have had at least 6 or 7 paragraphs, but I'm sorry, there are only 2.
Thank you very much. Thanks a lot.
I have to mention a very special note that on the social front, his efforts are very encouraging and heartening. With his firm, Suhas has developed a portal for free legal aid and advice ecosystem that caters to Maharashtra police martyrs, families, and police veterans, along with a lot of work that is being done for the sports and many other fraternities. A lot of good work which is also not made public. This is what I can say about the firm
Thank
Legacy.
you. Thank you very much.
Pleasure. Very happy to have Mr. Rajesh Bagga with us as well today. Welcome, Mr. Bagga. He is the founder of Yuhina Law Advocates and Consultants. He has been a group counsel with Unilever, Tata Motors, and Reliance, with experience in various sectors of the industry, both in India and overseas. He has been closely involved with the development of government regulations. And the 3 names that have been added in his introduction paragraph speak all about the size or the exposure of operations Mr. Bagga has taken care of. We are very pleased to have Mr. Dinkar Pagar on the panel. Welcome, Mr. Pagar. Pagar Saab has a rich experience in the field of resources, specializing in industrial relationship movement of Maharashtra for around 35 years in various positions such as the Joint Labour Commissioner, Mumbai Educational Labour Commissioner in Pune and Mumbai both, and Deputy Commissioner Labour at Mumbai and Nasik. Definitely very hot seats to occupy. He has also been the chairman of various labor boards and security guard boards of the state of Maharashtra. Welcome, Mr. Pagar. Very happy to have Mr. Apurva Sardeshmukh. Apurva is also a partner with Legasis Partners and has advised a variety of private equity firms, venture capital firms, investors, foreign companies, and domestic companies on various aspects of corporate laws, investment laws, forex regulations, commercial laws, IT, as well as labor laws. I don't know if there is any book that you have missed, Apurva.
Paper at least.
In 2019, Apurva authored The Data Protection Law and Regulation, a book which analyzes privacy laws across the world and which was published by Thomson Reuters. Welcome. Happy to have you on the panel.
Thank you, sir. Thank you very much.
And we have Kaustubh Athavale. He is an experienced lawyer and an associate with Legasis, and is keeping the entire panel tied and bright today for us. Welcome, Kaustubh. I hand over now to Suhas to take this interesting discussion and session ahead.
Thank you very much, Colonel. I think one thing I must mention is that, with Mr. Bagga and Mr. Pagar, with Apurva and Kaustubh, I don't have to open my mouth. You see, the kind of experience that Mr. Bagga has, there is one element to it which I must mention, is not only he has headed legal functions and he has been general counsel, but he has actually handled HR together with legal function at large companies such as Tata Motors. Thank you very much, Mr. Bagga, for joining us. And of course, I think with Mr. Pagar, I don't have to say anything. Kind of a regulator that he has been. The kind of cases and the kind of matters that he has looked at, handled, although we were on the other side when we were working with the companies, but we always respected Mr. Pagar for what he is. And therefore, thank you very much, sir. Thanks for joining our panel here today. I'm looking forward to an interesting discussion. I'm going to request Apurva to take over and take us through in terms of brief timeline and background, and then we will start the fire. Thank you very much.
Thank you. Good evening, everyone. Thank you, Colonel Chandok, for that kind introduction. Thank you, Mr. Shivprasad, for the introduction as well, and thank you for giving all of us this opportunity. This is as you know, Okay, I think the first. I hope I'm audible to everyone. All right.
Yeah.
Okay, great. So I think this is a topic that is, been widely discussed, widely debated, impacting almost everyone in the corporate world, in the not so corporate world. And of course, it's a topic that has come along due to the unfortunate set of circumstances that has hit the entire globe in the last 4 months or so. I think before we sort of start discussing the nitty-gritties of the Supreme Court order and the sort of background around it, certain couple of points that I wanted to sort of touch upon. Can the presentation be put up? Can the screen be shared, please?
Is it visible?
Yeah, it is. It is.
Okay.
You can move to the next slide, please. I think before we start, I think as a matter of sort of practice and we would like to, we always do this, we would really like to express our gratitude to some of the frontliners. I think fortunately, and I hope everybody is safe and healthy, and all of us today are participating in this webinar being safe and healthy. But I think we should take a moment to just sort of thank all the doctors and healthcare professionals who are, sort of working tirelessly in what really are very, very extraordinary and difficult circumstances. And of course, the police force in different cities, who have maintained the law and order during the lockdown, during the unlocking of the lockdown. Certain individuals like artists who sort of brought positivity and hope. I think as a matter of practice, we generally would like to sort of express our gratitude. I'll just take a moment to say thank you to all of them. These words are not enough to express this, but I think all of us here are indebted to all these wonderful professionals who sort of tried to make life as normal as it could be over the last 3 months. Kaustubh, we can move on. Oh, I think we've lost Kaustubh. So, okay. Mehak, are you there? Do you have a presentation copy?
Yeah, Kaustubh is just a minute.
Kaustubh has dropped out, sorry.
Yeah.
Anyway, I think while we sort out the presentation, I think there's just a few sort of qualifications and caveats that I would like to put forward. As lawyers, I think I cannot say, give or express anything without mentioning qualifications or caveats. I think it's important to understand that this is a webinar, basically just like it's a general awareness of the implications and developments around the topic that we are discussing today. I think at no point should anything that we say here should be considered as a legal advice or opinion. We are trying to sort of update everyone and express our views on the developments relating to Supreme Court order on payment of wages. But if a formal legal opinion is required, we would request you to approach your legal advisor and seek that. We also need to understand that the current situation is dynamic and it's uncertain. It keeps changing. Even the Supreme Court order that we're currently discussing, large parts of it or most parts of it are currently interim in nature. There are going to be additional hearings sometime in July on the order. So the order is not a final order currently. It's interim in nature, although it has implications currently on the employers and employees. So whatever we discuss is obviously, with passage of time bound to change. Also, what may happen, is that we are seeing that each day, each sort of week is seeing some sort of new regulations being brought in by the government, some sort of notifications being issued by the government, and perhaps certain notifications or regulations that are brought about in the future may also impact or may sort of modify what we are going to say during the course of this seminar. We are taking an eagle eye view. We are dealing with some of the critical issues, but those are points of discussion and debate today. As I said, it should not be construed as a legal opinion. And of course, these are personal views and do not represent the views of the participants, the organizations of the participants. We can, hi Kaustubh, great to have you back. Can you move to the next slide, please? Right, I'll just sort of set down some of the agenda, and I think while we'll be discussing the Supreme Court order in this webinar, we will also highlight the background which led to the Supreme Court and discuss the the circumstances which led to the filing of the petition in the Supreme Court. We will touch upon the sort of the grounds and the views taken by each sort of petitioner, and of course analyze the Supreme Court's judgments. And finally, of course, we will try and see the effect that is going to have on the Supreme Court order and the way forward. Right. I think fundamentally it is important to understand that this COVID-19 was an unprecedented black swan event. But what it has done is in the employer-employee relationship is sort of opened up a situation that was earlier not seen. We actually have situations right now where a lot of the employees are saying, look, we are happy and ready to work, but the lockdown makes it difficult or does not make it possible to reach our workplace. Hence, we should not be punished and our wages should be paid. Conversely, a lot of the employers were sort of were saying, look, how can we make payment of these wages when our workplaces have been shut down, no work has been done, and consequently no revenue has been generated, and hence we really don't have the cash flows to maintain to make salaries or make payments of wages with respect to our employees. We also had a situation where traditionally it has been a globally accepted principle of the no work, no pay principle has been a globally accepted principle, even under the ILO conventions and treaties. But we had situations where, in fact, even in case of the Aurangabad bench of the Bombay High Court coming out and saying, look, in these present circumstances, these are extraordinary circumstances, the no work, no pay situation does not really apply currently. So the fundamental relationships and principles governing the employee-employee relationships were no longer in existence. And if you look at each perspective in isolation, without you perhaps each party may perhaps have valid grounds, and hence the employer-employee relationship has taken a totally new context, so to speak. Also, we've now reached a situation during the lockdown, post-lockdown, in view of the judgment of the Supreme Court, the order of the Supreme Court and other aspects, whether a congenial work atmosphere, particularly as we'll see when the Supreme Court has advised that workers and employees should get into a negotiation mode, can exist, because as I said, in isolation, both have their own perspectives, and can actually a negotiation between an employer and employee be a fair negotiation. The other aspect that we need to consider, that one of the hardest hit sector currently due to the COVID outbreak and the subsequent lockdowns was the informal employment sector. And informal employment is very strong. Is this now a situation where we need to sort of look to formalize the informal employment as well? Are we looking at that scenario in view of the latest developments? Yeah. Right. So I think while the hotly debated sort of circular has been the March 29 circular issued by the Ministry of Home Affairs, which said that all the employers, be it in the industry or in shops and commercial establishments, shall make payment to their workers. We need to understand that even on March 28th, the Ministry of Labor had advised employers not to terminate employees or deduct wages. And I think the first question that before we go to the Supreme Court orders, so to speak, and I would like to ask, bring in Mr. Pagar here first, in his views. Pagar sir, these primarily were sort of earlier were referred to as advisories. So is it fair to consider these were advisories? I'll just keep the Supreme Court decision and the case around it aside for a moment. But these sort of circulars that were issued, be it the March 20th, the subsequent was on the state government, were these advisories? Would they be sort of binding? How should employers and other people look at these kind of advisories when they have been issued? Sir, I think you're on mute. Sir, I'm not able to hear you, sir. Hello? I think we can't hear.
Mr. Pagar Sahab, either you are on mute or we are not able to hear you. Hello.
I think.
Hello.
Yes, again.
Pagar. No, we're not able to hear you, sir.
I think till Mr. Pagar, we sorted out the audio at his end. So, would you like to sort of come in? I mean, the same question to you. How should we look upon it? Are these advisories, or what is your view on these?
Yeah, I think if you look at it typically, this is not the law. In a sense, it's not a direction issued under a particular law which would have to be required to be implemented as though it's a law. It was more a general kind of a advisory in nature, in true sense, to say that yes, there is a stress here, there is a bit of a problem. You got to kind of consider this from a humanitarian perspective. In order to maintain balance, you got to kind of make sure that you don't terminate employment at this stage. You give them the job security. It was in that tenor that I look at this as advisories. Although when some letter comes from a regulatory authority, it has a force. It can't be taken lightly. But the intent behind it was to kind of make sure that there is no stress. Or if there are rogue employers, for example, they would be kind of put on notice via this letter. But it's not a law. And I kind of want Mr. Bagga's view also, because I think I don't see this as a law.
I think so. I got reconnected now. Can you listen me?
Yes,
Yeah,
sir. Yes.
Huh? Okay. I will just come up with this. One thing, the first advisory was from the Minister of the Labor, Secretary Labor, Government of India has issued it. It was in the terms of the advisory only to stress out and to give some relief to the workers who had not been mentioned, but they were workers who are in the migrations, casuals, temporaries, and employees. They have mentioned the words. But it was in the terms of advisory itself only, which has no legal force. But subsequently, when at Ministry of Home Affairs under the National Executive Council, under the DM Act of 2005, issued those orders, taking into consideration the section 10(1)(g) of the Act. That action, that advisory is mandatory, and in terms of the directory, to implement it and to
Correct. Sir,
implement it. It was a directory.
Yeah, I agree with you.
There is no option to the people. The option was not been given to the people, to the employers or to the employees or to the society, not to do it anything. But it was to be done in positively.
Sir, we'll come to March 29.
Yes.
But let's look at March 20th.
And it was just March 20th was just an advisory
only. It was an advisory. In the normal course also, without COVID, these types of advisories are issued from government to government, from one department to other department.
Yes.
And these are merely in the nature of advisory.
Yes. It was not. There is no law. There was no force of the law under that one. For that.
Correct. Because it talked about everybody, whether it was worker, whether it was an employee, whether it was contract employee, whether it was third party migrant labor, all of them were included when they talked about employers, or saying that please advise employers not to terminate or deduct the wages. Mr. Bagga, I think just want your view from the point of view of, let's say, if I was in-house lawyer and I looked at this advisory coming on our table, although we will take it seriously, but at the same time we'll advise the management, this is not law. Am I right?
Yeah, certainly, because one, I think it was rather an emotional kind of an appeal, and there were already actions taken by other governments across the world which are very, very different. and which were participative and not directory in nature. Now, here was, I think it was rather a knee-jerk kind of a reaction to the situation which was evolving, knowing fully well that this is not going to last for a week or two, it will last a little longer. So that's why I think it took them time to swing in the, the DMA and other legislations and then pass, legislations.
Okay. Apurva?
Yes, sir. Thank you. So I think, thank you, Mr. Bagasoas and Mr. Pagar for that clarification. We then move to the most sort of important date in the context of this discussion, and that is March 29th, where the Ministry of Home Affairs issued the order, and this was, as I think the panelists have already touched upon, this was issued under the Disaster Management Act, which was invoked on March 24th, with effect from March 25th. And very clearly what that order basically stated was that employees should make payments of wages to their workers. I think critically, it sort of said all, Suhas touched upon it, it covered employers within all the domains, so to speak. It did not differentiate between public, private, or anything to that effect. Even touched upon the fact that contractual workers and laborers should also be paid. Now, this is where the panic buttons, if I may use the word, among the employers started to sort of ring, because this was now perceived to be an order. It was perceived to be order under an act, and hence perceived to be legally binding on all employers. Following up on that, various state governments also sort of issued orders under it, and under the in sort of a continuation of the Ministry of Home Affairs order. So before we go to May 17, before we go to the unlock the subsequent orders, again touching upon just discussing this topic with all the panelists, and Mr. Pagar, I'll start with you first. So without bringing the Supreme Court judgment order into the view, the March 29th order then would seem to be something that would be binding on all employers, and something that the employers would then have to honor in view of the fact that it was issued under the Disaster Management Act. Would that be a fair sort of conclusion? Mr. Bagasa? Hello?
Mr. Pagar, sir?
See him in the list. Bagasa, are you there?
He's struggling with his.
No, sir, I'm asking you. Sir, I'm asking you, sir. Sorry.
I think Apur.
Yes, sir.
Well, I think he's struggling with his instrument, I think.
Rajesh, sir, can you? I'll direct the question to you.
I got a question.
Sure, sir. Yeah.
I think if you can also just while I'm speaking, source the next para after this also.
Right.
But the words here to be noted, one is the direction to pay wages to all the workers at their workplaces on due dates. The words to be noted are without any deduction. Now that clearly is a departure from what is written in the Payment of Wages Act, which allows the employer to deduct on certain counts, including absence, etc. If you see the very next para, it actually rules out deductions on account of absence. It also directs the employer not only to pay his employees, but also the employees of his contractors and daily wages, etc., etc. Now, I think that part is really going far, far beyond the general law of the land and also the international treaties of ILO, etc., which we referred to, because wages is a consideration for work done. Wages is a consideration for having come and participated in the employer's business. Now, to rule out any deductions, even if the person doesn't want to come, is really out of the ordinary. So it was more of a, it was like in the old days when the king could rule, but here, the present king is actually ruled by the constitution. So that's why challenges took place.
Right, sir. And Suhas, while this slide is not shown, subsequent to this order, there was also the interim order of the Aurangabad bench of the Bombay High Court, which basically said that the principle of no work, no pay will not be applicable in these present extraordinary circumstances. And all of this then meant that the pressure on the employers, as Mr. Rajesh Bagga pointed out, was to pay the entire wages, irrespective of the fact where the employees were working, where the work where the premises, the factories, the work establishments were operational or not. That was basically that was something that everybody deduced from these two developments. Will that be a correct assessment?
Yeah, I think what happened is, if you look at the wordings of the subsequent circulars that were issued by various authorities, you see, they took umbrage under the advisory issued on 20th of March and the MHA order on 29th of March. And they started kind of using the same words that were there. Like, for example, you will see, if you read the text of all these orders and directives, if not, orders would imply that they are competent to issue this under the law. But these directives actually use the same phrase that were used on 20th of March to say that, employer should coordinate. Now, coordinate with whom? Instead of cooperate, the word used was coordinate. Now, and that word continued in every subsequent circular. So the non-application of mind and the fact that whether this constituted law or not was never looked at by anybody. You talk about the Aurangabad High Court order, I think the facts slightly varied. But the moot question was Aurangabad High Court looked at it to say that these are extraordinary circumstances. Can you actually deduct the pay and apply no work, no pay principle during the period of these extraordinary circumstances? Under one facts and circumstances, it said no. Under different facts and circumstances, it said yes. Now, therefore, readiness and willingness to provide the place of work and the work from the employer's point of view. Employees were ready and willing to go to work, but their movement was not possible. Neither was the workplace open because of a complete lockdown. I think what you articulated earlier was the situation, and therefore, I think only as a temporary measure, Aurangabad High Court seems to have said that, sorry, don't consider this during this period when it's impossible for somebody to go to workplace. You don't throw at him the rule book to say no work, no pay, and you will not get paid. That seems to be the logic. Whether it is correct, whether it is wrong, I don't think we should be competent to comment upon it, because the facts are going to vary. And I think the law as laid down by the Aurangabad bench, now clarified by the Supreme Court, appears to be only for a temporary period. So that's my take on the no work, no pay during the core period of where the lockdown has prevented workmen from going to workplace or from employers to offer employment or the work.
Thank you, Suhas. Pagar sir, can you hear me?
I hear you, certainly. Yeah.
Yes, sir. I just wanted to just quickly check with you, sir. As the last point on this slide suggests, on May 17th, when the lockdown 4 guidelines were issued, it stated that the 29th, all previous orders issued under the Disaster Management Act expired with effect from 15th May. That would include the March 29th order as well. Sir, I wanted to check with you, subsequent to the March 29 orders, there was sort of advisories issued by the state labor departments as well, various state labor departments. So what is your view?
Yes,
Do those
28 months. Yeah.
expired, or would the state government separately have to issue some sort of advisory, or would all of these orders issued by state labor departments should also stand withdrawn?
No, MHA orders were already 20, even the earlier 17th May, no, not 17th, 24th March 20 orders were very clear for every state has to give the direction under the state executive councils, and then the district executive councils have to issue the orders.
Right,
taking into consideration the orders issued by the MHA.
Right.
So
Right.
on the same line, as it was directed by the MHA to issue the orders, the state government has issued the orders. The
Right,
same
sir.
guidelines whatever the guidelines were there
Right,
in the
sir.
24th March, same guidelines were being issued by the state governments. In all the states have issued it.
So
So there is no repugnance. There is no repugnancy in this issue. It is just a continuation of the MHA orders only.
Right, sir.
Yeah, it is MHA continuation of MHA orders only. So
Right,
it has no, because it follows from the MHA orders.
Right,
It is
sir.
not
All
even it is not independently withdrawn by the state.
Okay, sir.
Yeah.
Right. Thank you, sir.
Yeah.
Can we move to the next slide, Kaustubh? Right. So I think my friend Kaustubh has been patiently listening. He's someone who studied the Supreme Court order and the facts around that very closely. So I'll hand it over to Kaustubh. If you could just sort of bring all of us up to speed on the various sort of developments around the petition leading up to the order.
Yeah, sure. So of course, the first thing that happened was the 20th March Labor Ministry advisory, and there was no enforceability behind that because that was just a suggestion to the employers. Then when the 24th March DMA Act was invoked, the next question that everyone had was, what was the DMA Act actually going to do? What was the Disaster Management Act actually going to provide? We saw that coming out on 29th March with the MHA order. And a lot of people were initially wondering where this power comes from. And a lot of other major employers, as well as a lot of MSMEs and a lot of some individuals also filed PILs throughout the month of April, challenging the MHA order on various grounds. First one, of course, was that Section 10(2)L of the Disaster Management Act actually doesn't give you the power to impose financial obligations on a private entity. Now, under the Disaster Management Act, you can see that the National Executive Committee actually has powers to direct different departments or different state authorities or central to allocate funds or measures or to request resources from private establishments, but even that to a limited extent. So when the actual petitions were filed, we saw a lot of activity coming from, in the legal community especially. And by the end of April, I think almost 3 major petitions were filed. The lead case in this was chosen as Ficus Pax. That's the Supreme Court order, the lead case under which all of the other orders are being passed. So the first substantial step in this was that on May 15th, the Supreme Court passed an interim order saying that the authorities should not take any coercive measures against the employers who don't follow these directions of the Ministry of Home Affairs. And I guess maybe as an immediate reaction to that, or possibly this was just a coincidence, but May 15th, we have the interim order, and within 2 days, we got the lockdown 4.0 guidelines, which said that every order passed under Section 10(2)L of the DMA would be withdrawn with effect from 18th of May. Effectively, that.
Kaustubh,
Yeah.
sorry to interrupt, Kaustubh. I received some chat box that your voice is not audible. Can you be a little loud?
Yeah, sure. I'll try to. So I was just saying, the last thing I said was that immediately after the interim order was passed by the Supreme Court, asking the government not to take any coercive action against employers. Within the next 2 days, we had the May 17th lockdown 4.0 guidelines, by which this order was effectively withdrawn. Of course, for the next few days, people were still wondering whether it has actually been withdrawn. And this was clarified eventually on June 4th, by the Supreme Court, by the Union of India in the Supreme Court case. So what the Union of India did was they filed a common counter affidavit against all of the petitions and intervening applications that were filed. Now, of course, the petitions that were actually filed were on various grounds. I mean, not everyone was challenging the MH order for the same reasons or asking for the same prayers. And the same way, the intervening applications had their own grounds. The PIL had its own grounds. So the Union of India decided they would file a common affidavit, a common counter affidavit. And according to them, the reason for that was to bring on record the legal authority of the MH order and the facts and circumstances behind its withdrawal. Now, the period between the actual order being passed till its withdrawal effective from 18th May is a 50-day period. And it's that period that we're actually looking at. That's when the effectiveness of the actual order still stands. And that's what's really being argued. On June 4th, the Supreme Court, then after hearing all the parties, all the interveners, they decided that they would reserve the case for orders on June 12th. And that's when we actually got the order from the Supreme Court. But before that, we could go into...
Sorry to interrupt. Your voice is dropping off. I think you need to be closer to the mic for some reason.
Nothing. I was just getting to the point that on June 4th, the Supreme Court reserved the case for orders and said that on June 12th, we would come out with the order, and that's what we're, I guess, discussing today. But we could go into the grounds of it before we get into the order itself. So I can move to the next slide.
Yeah.
So is this visible to everyone?
Yes.
Okay. So, of course, like I said, there are many grounds for challenging the MHA order. I think one of the primary ones was that the Disaster Management Act actually does not give any kind of power to impose financial obligations on private parties. There were also some petitions saying that this would be a violation of the employer's rights, even if that MHA order was passed correctly. In other words, if the MHA order was actually based on a provision which is present in the Disaster Management Act, then the provision itself would be unconstitutional. So that's one of the challenges that we're seeing today. On the one hand, you have a challenge to the MHA order. And even if that succeeds, even if the MHA order is held up by the Supreme Court and it says that that was correctly laid down, the next challenge that the Union of India would have to face is whether the provision which the Disaster Management Act actually has, under which the order was passed, whether that itself is constitutionally valid. So the ground provision itself is contrary to the Constitution. Some other petitioners, especially during the hearings, something that came out, something that a lot of the councils were pleading was that if you force us to pay wages when we ourselves don't have any income, even the stable businesses which were doing fine before the lockdown, and that was also a very shaky period for us. But even the businesses that were doing fine that time, they would also be forced into insolvency, and we did see that happening in the world. One of the other alternatives given by the petitioners for what the government should do or can do or could have done is that there were various funds that are accessible to the National Executive Committee that's formed under the Disaster Management Act. And one of the specific powers that is given to the national as well as state executive committee in the case of a disaster is that they can draw from funds from different departments. They can decide that, okay, look, normally we use this fund for objective A. Now we have a disaster. We need to allocate it for something else. That power is present under the Disaster Management Act. Now, on the other hand, the Union of India and the Employees Union together had various points on the basis of which it could be argued that the MHA order should be upheld. Of course, one of those is the overriding effect of the disaster management. That has biggest implications, and that's where a lot of the arguments will come from. The other is that there's a pre-existing right under labor laws as well as the constitution that employees have a right to wages. In other words, if I am ready to come to work, if I'm ready to be present, it is not my fault that the work is not available to me, or that the office or the business is not available to me to access.
Yeah, Kaustubh, I'm sorry. Thank you very much for outlining these, but I'm going to butt you in, and I'm going to request some views from Mr. Pagar as well as Mr. Bagga on the grounds and the rival contention. You see, before you proceed further, so I'm going to see. I'm going to request Rajeshji to kind of look at the situation where I think MHA's order is now, employers are claiming that it's violative of the Articles 14 and 19(1)(g), which is to say that fundamental rights are being abrogated via this order. I have a right to kind of have my own trade, to conduct my business. That's being impinned today because you're trying to tell me that whether I have financial capability or not, I need to continue to pay the employees. You're not looking at what my rights are under the Constitution. So to that effect, this is contrary to or ultra vires the Constitution. That's one contention. Now look at the answer to that, which is kind of provided by some of the interveners, which are like the unions who have intervened in the matter, to say that all the labor laws, follow from this fundamental right. So in fact, the fundamental rights support the case of the employees and not the employers. Sir, I just need your views and then Mr. Pagar's view as well as Apurva's view on how do we look at this situation now?
Yes, Suhas. So I think the whole approach of the government has been that it's a serious pandemic and there is a huge human tragedy that has taken place, and that we need to provide for the welfare of the workmen during this period. And also, I think the effort was, as is stated in the affidavit of the government, to alleviate the problems of the migrant labor. They have not provided any answer, and that's what the Supreme Court said in its order, to the other grounds of the employers, which said that how can I be asked to pay when the person is not participating at all in the industrial activity, number one. Number two, my own orders, my own cash flows, my own inventories are casting a huge burden on me. I am out of pocket. And to paint every industry with the same brush is also not right. There are certain industries which are heavily dependent on migrant labor. There are certain industries which have next to nil migrant labor. They have permanent workmen. And if I am required to pay, the employees, if I have the fundamental right to conduct my business, the employee also has a fundamental right to employment. But both my right and his right come with a few duties. The duties on me are that my industrial activity must be ready and up to be run, and that I should then open my gates to the workmen to come and participate. The duty of the workman is to come and participate and give his sweat and toil and earn the wages that he is contracted for. Now, here is a situation where the industry is unable to open and the workmen possibly are also unable to come. On what ground and under what legislation can the government then direct the employers to pay the full wages? You see, the problem came when they said with no deductions.
No deductions.
Otherwise, thought out directive that, okay, you start paying advances, we will try and adjust them later, so that subsistence of workmen can take place, could have been a sustainable option.
Right, correct.
Now, to seek that, it was only a 50-day measure, is actually doesn't cut ice, because Mr. Pagar is far more experienced, that a 50-day window, if I open now, that 50-day window will become a precedent for various 2-day, 1-day, half-day, 30-day events later on. Let us say my factory is in Panvel, which is under curfew, and all my workers stay in Andheri. If I cannot open my factory, am I required to pay them? If I do this 50-day thing, then I will have to pay them full wages.
Yeah.
So therefore, I fully understand that it was an unprecedented situation, but there is a fallacy in the entire direction that has been issued, and it doesn't gel with the international practice either. US, for example, has chosen to pay a part of the wage bill of all employees, all companies, which they are supposed to pass on to the workers. So therefore, in the face of such other measures taken by other governments, it is a little far-fetched to insist on full wages. Full wages were not required because there is a let's say a reduction of liability of the employee as well to run his home during this period, because he is confined to home and we are all confined to basic necessities.
So in this, yeah, sure. Sorry. Please finish.
So therefore, I understand that as an employer, I have a duty to be benevolent and to be responsible, and also to take care of my workers and their welfare through thick and thin. But I'm now faced with a double whammy where my inflows are curtailed 100% and I have to pay 100% wages. Look at some of the industries which are wholly dependent on manpower, where the wage bill actually is a large component of the fixed expenses. Where is he going to generate that? So I leave you with that question.
No, thank you. Thank you very much. I mean, before I move to Mr. Pagar, I think there is one thing that you talked about US, and I want to mention, Swiss Federal Council in this regard. Swiss Federal Council actually kind of came out with measures to mitigate the economic consequences, to say that, employees who are no longer able to work because either they need to stay at home because the workplace is shut down, or they're self-quarantined, or they're required to stay at home to look after their children. You see, they went to that extent. They said, please, we will compensate. They told employers that you pay and we will compensate you on behalf of the employees. That's US Federal Council. It not only, directed or it not only came out with this compensation, federal compensation policy, it also went a step beyond that to say that anybody, and in Switzerland, there are a lot of people who come from neighboring countries to work. So they said anybody who comes to work in Switzerland is today unable to work, can make an application for compensation to Swiss Federal Council, and we will consider that, and that compensation virtually is now granted. In this context, there is one ruling of the Supreme Court which is reported in Germany, which is a Switzerland top court, to say that if an employee is asked to work from home, the employer may even be liable to pay the rent of that employee. It's gone to that extent in terms of saying that as a government, we are responsible and we need to provide in the economic consequences. So, Mr. Pagar, I mean, I just wanted to share this in the context of what other countries are doing. I came across that judgment where they are saying if you are asking somebody to work from home, you have to take care of his rent, because
Take
that's
rent also, yeah.
now. Sorry,
Yeah,
Mr. Pagar. Please.
yeah. The examples which I already given is quite an exemplary example for us, because the because the economy and the social structure of those countries is altogether different from the Indian cultures and the Indian society also.
Sir, that doesn't allow you to penalize employers.
No. But look here, that is gone more benevolent. But beyond that, we cannot go to that extent. But the extent for which MH order of 24th March is the existence is there. We are talking about that order, whether to pay the wages for the workers or not, and what the circumstances are there. Supreme Court has said that, MH order said that no deduction of the wages, and whatever the due date, workplace, all those things are there. Even we are opposing to this order for the reason that the principle of no work, no wages principle is already there. Employers has no capacity to pay the wages if there is no production or there is no generation of the revenue. Basically, these two things are there. When revenue generation is not there, naturally, from where he is going to source it? Because whatever the stimulus package is given by the government of India to the Indian industry, and a stimulus package given by the other countries to their their general citizens, it is given to the citizens, not only to the employees. So it was on that the package was on the basis of the consumptions, and that is the demand, so that your survival can be there. And in the India, for the survival of the person in the public interest, the MH order was being drawn, and in the public interest and to mitigate the hardships faced by these migrant laborers, whether it is interstate migrant laborers or intrastate migrant labor. Look here, we have to see from the two angles, intrastate as well as interstate also, both way.
Correct.
It's not only interstate issues, it is also intrastate issues also there. So these two things we have to consider it. And third is main portion is with the regular and permanent workers of the country, industries. So there are two sets are there. Permanent regular workers of the industries, number one. Number two is the contract laborers, temporary workers, casual workers, apprentices, NEEM peoples. The second set is there. So first set of care of first set is already been taken by the number of companies.
Sir,
many companies have taken care of those first part, but second part peoples, that is a migrant, that is the contract laborers, temporary workers, that their what should you say, the care has not been taken by the employers despite the Supreme Court order for the same reasons. That their capacity for the same reason that they no work, no pay, number one. Number two, capacity not to pay the wages because they have not generated the revenues.
Yeah, sir, I think you're right. I think large part of discussion in the Supreme Court or the Supreme Court interim order seems to be around the fact that the employers are struggling. They do not have capacity to pay. The revenue shrinkage has happened. And therefore, they are on the verge of being wound up.
Wound up, yes.
And in some cases, it has been articulated to say that, how could you ask somebody to continue to pay wages when, because of the discontinuation of work, you are on the verge of bankruptcy? You do not have adequate funds to pay. And therefore, from that perspective, there seems to be this, tight rope walking stick and balancing act that Supreme Court is trying to arrive at. Can we move on to, therefore, on the grounds, the second part where I would like you to kind of like both your views as well as Apurva, I'm sorry, I'm going to come back to you first on that, is that the overriding effect of the Disaster Management Act. Will Disaster Management Act hold the fort with respect to payment of wages? Let's assume there is an inconsistency, or how would you look at this overriding effect of Disaster Management Act? Apurva?
Yeah, thanks, Josh. I think the answer to that question in terms of the Supreme Court order, the Supreme Court really hasn't ruled conclusively on that.
it is pertinent to note that the government has sort of pointed out that their ability, their power to issue this order under 10.1 stands, 10.1 Section 10.1 of the Disaster Management Act, in view of the fact that they have powers to regulate policies once a disaster situation is prevailing in the country, and the Disaster Management Act has been provoked. Whether the disaster management, under the Disaster Management Act, the central government can issue orders to this effect, there is no conclusive, to my mind, decision yet by the Supreme Court. While the government is still claiming that they have the powers to issue it, the finality to that has not yet been seen.
Yeah, so I'm going to, sir, I'm going to come back to Mr. Bagga on this. Sir, I mean, if you remember, we had this Essential Services Maintenance Act, where all the power plants were required to continue to operate, irrespective of the financial hardship that came in. If we were to extend the same logic here, because under those, I mean, if you remember that Orissa Power Corporation was actually asked to continue to work and operate the power plant as essential services. When some of those foreign expat employees actually left the plant. And I think the government came out, that time it was a state government, came out with a directive under ESMA to say that you need to continue to operate the plant irrespective of what the financial repercussions on you are or what your hardship is, because in the larger public interest, we need this power to continue to flow across the state. So we have certain precedents under like ESMA. I don't know in terms of eventually what happened on the employment side, but the directions were given to continue to operate the plant. If that's a larger public interest, then would Disaster Management Act not have overriding effect over the labor laws?
So let's take the example of hospitals. If I am running a hospital today, you have, and the governments have directed that hospitals will continue to run, whether they are profitable or not. So what I think is the question here is, the government wants to extend a social help or measure to the migrant and other workmen, but it wants the employers to pay.
Correct.
Without any running business. Both the power plant example and the hospital example, the establishments continue to run and generate revenue, and the cash flows are intact. Here, by your own action, the industry has been asked to stop or continue to work under, serious restrictions. Now, if a social measure is to be put in place, then I think that's what is being stated in the petitions as well, that please participate in the fallout of that social measure. You cannot just pass a directive and sit aside. And number two, I think in the face of a complete private enterprise, and I am not sure that the Orissa establishment was a completely private enterprise.
It was private. It was private.
Completely private. Okay. Now, this is like the nationalization of banks kind of an issue.
Correct.
Now, so therefore, I think there are serious issues which have been raised in the petitions, and the grounds seem to be very much on line of a misuse of the general power granted under 10.1 and its extension to 10.2, which the employers have said did not extend to the modification of labor laws in the manner it has been done.
I understood. I mean, I take your point. Pagar Sahab, I mean, have there been instances in past, like the invocation of ESMA, where some other authority of the government has directed that the operation should continue or should stop? and payment of wages should be made, irrespective of whether the directive allowed the people to operate or not to operate. Are there any similar precedents and examples in your experience today?
Yeah, it is there. For continuation of the operations, directions already under the ESMA directions already been given, always been given to the especially the municipalities, municipal corporations,
yes,
hospitals, government hospitals, especially these are always that wherever the strike notice is being given by these unions.
Correct.
ESMA is always been invoked.
Correct. Now,
but at even based, but at no time, the implementation of ESMA has come into arise.
No. Now reverse the action.
Reverse the action. Reversing the action, presuming that a certain factory is polluting industry is there and the environmental department is directing it to close it down. Especially very always the issue always comes over there. Sir, but in those circumstances, workers' wages have to be paid.
No. Now there is a default. No, sir. One of the contracting party is defaulting, which is giving rise to the obligation to pay, which is a different scenario. You see, sir. Therefore, this is black swan event. I completely agree with you. If an industry is polluting, it is in breach of some other law. It is in breach of its obligation.
Yes.
There is a polluter pays principle.
Absolutely.
Yes, please.
Yeah. So that you can't equate that example with the current situation.
No. You ask for the two examples when the ESMA has been enforced and where the factory has been directed to close it.
Yes.
So in that sequence, I will just reply for that one.
Fair point.
Yeah.
Sir, therefore, which is the larger public interest? Now, if you have to look at the public interest, and Bagga Sahab, you mentioned about Disaster Management Act 10 provisions of section 10.2 and 10.2L, 10.1 being general in nature. I would say it's a law which kind of holds a very, it's a special enactment, not a general enactment, because it will apply temporarily only in cases of disasters. It will not apply in a normal situation. Therefore, it is a special law. The provision under 10.2 or 10.1 may be general in nature, but it's a special law. So when it comes to provision of special law and the inconsistencies which are there flowing for section 72, would DM Act not override the labor laws?
I think it's a fair point and an arguable point, Suhas. But please see that in an economy or in a constitutional framework where you have a balance which is struck between labor and industry and also the government, to now come up with a directive which is only cutting only the employer is something that needs to be looked at. And please understand that we are not a fledgling nation. We are a semi-developed kind of a nation where wages have traversed a long way from subsistence to really we are knocking at the doors of living wage in many organizations. Now, in that kind of a situation, to now say that living wage needs to be paid for a pandemic and that too for a temporary one, is not fair when the employer is totally locked out.
Fair point.
And you leave out the biggies. Please look at the small operator.
Correct.
If I was running 5 shops in malls of a particular city, where would I stand today?
Fair point, sir.
I'm actually, done with. And that's why, please see that somebody, I think Mr. Pagar mentioned the package given to the industry. The package actually recognizes that a whole lot of industry will get into the clutches of bankruptcy.
Correct.
If that is so, then that aspect needs to be taken into account when you direct employers to pay full wages. Because if I'm already standing at the doors of the NCLT, then I have a serious issue paying more. Thank
Fair
you.
point, sir. I mean, that's where I think probably in the interim order, and I'm going to, sorry, Apurva, I think I have to come back to you on
Right.
the orders as well as your take on the overriding effect plus how do we look at the interim orders now?
Sure. Thanks, Suhas. Kaustubh, we can move to the next slide. Yeah, I think till the time we go to the next slide, I think quickly touching upon the highlights of the Supreme Court order dated June 12th. I think before we go into the order, a couple of things that we need to understand and the panelists have sort of touched upon. The first aspect being that during the course of delivering this order, the Supreme Court did observe and based on a counter affidavit filed by the Government of India, as Kaustubh pointed out, that with effect from May 18th, the Ministry of Home Affairs order dated 29 March stood withdrawn. So in effect, the restrictions or the directions of the order dated March 29th, 2020 would be applicable or would be in effect for 50 days, the time period being March 29 to May 18th. Having said that, what the Supreme Court basically said was, look, the employers and the employees, industry and laborers need each other. And in view of that, it is better, it would be advisable if the employers and employee, get into negotiations to sort of discuss and agree upon a formula which sort of would a formula for the payment of the wages of the employees. And what basically the Supreme Court said that if the establishment industries are willing to enter in negotiation with workers for the period of this 15 days, where this industrial establishment was closed down, this process of negotiation could be initiated and employers could get into a settlement with the employees. If they are unable to arrive at a settlement, then the employers and the employees can actually submit a request to a concerned labor authorities, who have the powers under the different statute to try and conciliate this dispute between the parties. And on receiving this request, the concerned employee trade unions or worker associations may appear in front of the conciliation officer with the employers for negotiation. It is important to understand that a settlement can be arrived irrespective of the order of March 20th. So the settlement can irrespective of the order, in that for the period of the 50 days, employers and employees can reach a settlement with respect to the payment of wages. Further, it was clarified that employers, establishments who are working during the lockdown can also take steps for settlement and negotiation with respect to the payment of the wages. The Supreme Court also has sort of directed that private establishments who take the steps with respect to payment of wages shall communicate about such steps to workers and employees so that they can participate in this negotiation process. And of course, the central government and the states and union territories through their Ministry of Labor have been requested to circulate this order. Another point that needs to be touched on is not in the June 12th order, but previous to this order, the Supreme Court had stated that no adverse action should be taken against any employers for non-observance of the circular dated March 29 till the finality of this decision has been taken. Sorry.
Apurva, it was no coercive action to be taken.
No coercive action. Sorry, yeah, no coercive
action to be taken.
Yeah, no coercive action. Sorry, no coercive action, and that interim order also continues. In that.
So Apurva, I think. See, let's spend time on the 4 interim measures that the Supreme Court has actually directed. Right. If you look at the first interim measure, they say the private establishment, industries, employers.
Yeah.
So I think whether the ambit of the 29th March circular was only limited to the migrant workmen, or it extended to other employers? I think actually this is enlargement of the scope of the petition. They say the private establishment, industries, employers who are willing to enter into negotiation and settlement with their worker stroke employees regarding payment of 50-day wages. So am I right in reading this? I would need Mr. Pagar as well as Mr. Bagga to comment on this, to say that therefore this actually enlarges and negates the question of whether now the question before Supreme Court is only relating to migrant workers, because that was one of the arguments put forward, whether it related to contract labor, whether it related to industries, whether it related to other establishment. Actually, by this interim order, has the Supreme Court not enlarged the ambit and the scope of this adjudication?
Suhas, before Rajesh sir and Pagar sir come in, just expressing my views, I don't think there was this difference in the 29th March order, though. I don't think it's sort of...
There is no sequence. There is nothing. It is general in orders. It is not for the contract laborers, not for contract labor, not for regular workers. It is for everybody.
No, sir.
Whosoever is employed. No. Whosoever is employed. Especially and their word is especially migrant labor. Wording is there.
I beg to differ with you. If you read the 29th March circular in entirety, it starts talking about migrant labor issue. It starts talking for this para. Everything else in March 29 is related to migrant workmen. And I remember, Colonel Chandiok, when we actually were conducting a webinar, you called me up and asked me whether this circular applies to everybody or only to migrant workmen. Sir, therefore, there was ambiguity. You see, there are a couple of petitions where this ground has been taken to say that, please clarify, this only applies to migrant labor. Because I can, if you read the entire 29th March, except for this para, everything else appears to be focused only on migrant workmen.
No, if I could add
I will not get into that, because my view is now Supreme Court has enlarged its scope. Now they're talking about all private establishments.
One important thing here, I'm sorry. One important thing here is that the Supreme Court did actually ask Union of India whether this was restricted in any way to migrant workers, and the response was that there was no such restriction intended. So at least
that's government stand. That's the government stand.
Right. So they have clarified that when they issued this order, they had no intention of restricting it to migrant workers. I think that cleared out that issue for me at least. But
so coming back to the interim relief which has been given now, or at least the order, it actually says every establishment virtually, and workmen as well as employees. So in that sense, the first direction that the Supreme Court has given actually encompasses within itself all kinds of establishments today. And it says private establishment, industries, employers who are willing to enter into negotiation and settlement with workers stroke employees regarding payment of wages for 50 days or for any other period as applicable in particular state during which their industrial establishment was closed down due to lockdown, may initiate the process of negotiation. So, sir, now I want to, on this first kind of a interim direction that is given, you see, it seems that they are saying everybody who is willing to enter into negotiation with their employees, either through third parties or with employees directly, should actually, this adjudication which is pending in the Supreme Court doesn't come in your way to kind of get into negotiations and settle the matters. Am I right?
Yes, naturally, because the door has been kept, now door has been opened by the Supreme Court that you negotiate and you settle yourself, irrespective of the MHA orders. It means like this only.
So, Mr. Bagga, when they say that while the matter would be pending in the Supreme Court, you enter into settlement.
Yes. enter into study naturally.
What will be the veracity of this settlement?
So the settlement, I think what has happened to us is that the employers and corporations who had good industrial relations and capacity to pay, etc., have already worked out with the unions on the issue. And they have signed either minutes of meeting or a proper settlement and have gone along and now possibly open. Now, but you see, the point is the others who have no capacity to pay, they are particularly been put in the dock. And you're right, if you read the Government of India's counter affidavit, which they filed, the shorter one, it has a sweeping coverage. He does not, in that affidavit, distinguish between migrant and other laborers at all. So the full definition of a workman under 2N of the Industrial Disputes Act is what is being referred to. So whether he is contract, whether he is temporary, permanent, migrant, non-migrant, everyone is covered in that sweep. And you see, the fun of the whole thing is that a temporary workman by nature is called in on a day-to-day basis. So that means the guy who was called in on the last day of the lockdown, before the lockdown, actually becomes permanent for 50 days.
That's a very interesting take you have, sir.
So therefore, I have a problem. Number two, I think no employer will hesitate from negotiating. I think that was a noble gesture on part of the court, also to soothe nerves down. The workmen face the specter of not getting any wages. The employers are today saddled with a liability of 100% wages. So therefore, both parties should wholeheartedly negotiate. And hopefully, I think this court will put an end to the dispute by August end. We are hoping. As I think it's a very serious issue. And I only hope that the general law of the land is not given a go-by, and it is whatever order is passed is not treated as a precedent for future, because it can seriously impact some working of the industry.
I just actually, so I wanted to check with Rajesh sir, Suhas and Pagar sir, in view of the Supreme Court order, can an employer today say, I will wait till July and August to see what the finality is, and then conclude my settlement process? Because there do not seem to be any indicative timelines as such.
Certainly, yes.
If I can answer, usually the Supreme Court's directive needs to be followed. I think you will be better off calling the workmen for a negotiation and hearing them out, and also giving your point of view, and hold the negotiation in a proper manner, so that you are also prepared and the union is also prepared for the final outcome of the petition.
Thanks.
Sir, I think you see, if you look at the second direction, which is part of the interim order now, is to say that those of the establishments where there was a work which was offered as well, so those essential establishments, so to speak, where not all workmen were there were few of them there working. It was not being worked in full-time basis. So there were various permutations and combinations. And the second kind of interim relief or the direction appears to say that those establishments which were working during lockdown period, although not to their full capacity, can also negotiate and settle. That means the stress which was there even on other establishments in essential category also seems to have been recognized by the Supreme Court while giving this direction. And before I proceed further, I think there is a third direction which is important, which says, and that's where I would want everybody's views here, which says that whatever you do now will be without prejudice to the rights of the workers regarding unpaid wages for 50 days. Private establishments who proceed to take steps as per settlement directions shall publicize, communicate. And one of the part of why we are holding these webinars is that the Supreme Court actually encouraged people to say that bring it to the notice of everybody, to all the factories, all the workers, all the establishments, that you are now permitted to negotiate and come to a settlement. You see, these are the directives. Now, in the backdrop of this, what does one mean when somebody says that these settlements will be without prejudice to the rights of the workers and stroke employees? Because as Apurva said, then can employees simply say that sorry, we will make the bona fide attempt to settle, but we will keep the final settlement lingering on? Will that be a kind of correct view to take?
All options are available. All options are available to the peoples. Whether to negotiate and to settle it, number one. Number two, to negotiate but to fail it. Number two. Number three, negotiate it without prejudice to the right of the wages of the worker for the 50 days. That can be also clause can be included in the settlement. That is one way of the settlement.
Okay, fair point, sir.
Yeah, this is one way. This is one way of the settlement. That okay, without prejudice, you have a right to come. Without prejudice, you have a right to claim the 50%, 50 days wages as per Supreme Court order. Let the Supreme Court order finally decide it. We will do it. We'll follow it.
Fair.
Till the time you accept the 30% wages, 40% wages, 50% wages.
Okay. Mr.
Or no wages. Or no wages till wait for the Supreme Court order. These three options in the third lines can be available.
To us, I wanted to add something.
Sure.
See, we are talking of negotiations between unions and organizations. What about small establishments where there may not be any unions? Then in such cases, the employers are going to negotiate with whom? The employees, I know, of course with the workers, but the employees over there would have a lesser bargaining power because they wouldn't have unions. Then the spirit of the order may fail because, you know, the actual negotiation in that strict sense may not happen.
Definitely, yeah.
No, look at it. Larsa, there is always a fear. There is always a phrase there. Don't fear to negotiate and don't negotiate under the fear.
that's very well said. But I agree with you.
But the point
certainly.
It is a very valid point.
If you fear it under the negotiations, naturally you are not going to gain it.
See, Shiv Prasad ji, my take is actually, if you look at the Industrial Disputes Act, Section 2P and 18(1), where in past we have worked out individual settlement with workmen. Okay, at times we have bypassed the unions and got into individual settlements.
Yes.
Which Pagar Sahab knows some of those.
Many.
I can see that. Because then what happens is, if that settlement is not violative of any of the provisions of laws, including laws relating to payment of wages in this context, if it is not discriminatory, in that sense, it doesn't discriminate within your workmen, one person and other person, it's applied and seen as a fair, reasonable manner, and you follow the due process, which means there are two witnesses when that execution happens and you are sending it off to the conciliation officers or labor officers and authorities as a 2P settlement. That is one-on-one settlement possible, even though your establishment may not have unionized workers. It's not necessary that it needs to be a tripartite agreement or settlement.
No, Suhas, I'm just sorry to interrupt you. I think just picking up from what Shiv Prasad ji said, in view of the relation between an employer and employer, a slightly different context, but I remember when the privacy laws were discussed, the Justice Sri Krishna had said that, an employer going to an employee for a consent, that's really not a valid point because the relationship between an employer and employee is different. An employee in a lot of circumstances will be bound to follow what his employer says. So how is this negotiation going to be? Is the employer going to go to an employee and say, look, this is what I'm going to give you, you sign this and we claim this as a negotiation? Or is he actually going to sit across a table and say, let me hear your views, let me protect my views? As are employers and an employee equal parties or on equal length to actually negotiate a settlement?
Yeah, so let me answer that. I think where the balance of power is not proper, that is why we have a very robust labor department. So the employee who is disgruntled or is not happy with what is the outcome can always approach the labor department, and labor department steps in to give a shoulder strength to that employee and ensures that what is reached ultimately is a decent package. And there's no, that is why the labor department is there, to bring that balance into the whole system.
You see, in this context, I think if I were to read the Supreme Court, the third direction there, it says the private establishment, industries and factories shall permit the workers to work in their establishment who are willing to work. If I have to break this up in terms of a very positive mandatory direction, so no employer can actually hold a gun to the employees to say that I will not permit you to work if you do not agree onto this 50-day settlement. Because that's a great balancing act. You see, if I mean, I completely agree with Mr. Bagga. I mean, the laws as well as the regulators will step in if there is something which is tilting the balance one way or the other.
Yes.
So in order to maintain the balance, and that's where probably we'll have to take these Supreme Court words very seriously. If somebody says that if you do not agree with me on accepting a 50% compensation for 50 days, then only I will allow you to come and work in my premises. I think that will be completely frowned down by regulators as well as the courts.
It is called unfair labor practice.
Yeah, sir, I'm not getting there because
it is called unfair labor practice.
Sir, I will not get into ULP and MRTP
Yes.
discussion because that's a different issue.
Man, in very short, I said only to this extent I restrict myself.
Absolutely, I completely agree with you.
Restrict myself, restrict ourselves to this extent.
So the balance, Apurva, will be maintained.
So, sir, one thing is that if you see the para 34 of the judgment,
yes, sir,
it's very clearly mentioning is that how it is to be processed.
Correct,
what it is saying, DMA order had already equally adverse effect on the employer and employees. It has been accepted by the Supreme Court that the adverse effect has been created on the employers and employees. One part, very clearly.
Correct.
Then secondly, what they are saying it, the industries are of a different nature, different capacity, including financial capacity. Some industries can bear the payment of wages cost or substantial cost, or some may not bear the cost at all.
Correct.
So balance has to be struck between these two competitive claims. Via media is to be found out.
No,
the word is via media is to be found out. When this word is very clear, he's mentioning it, that you can find out the way how you want to settle the 50 days wages issue.
Yeah. No, I completely agree. Sir, I think we are probably running out of time. So I'm going to rush through in terms of saying, sir, what are the kind of final comments, final takeaways? Mr. Pagar, from you.
Now, final comment will be like this, because basically when Supreme Court allowed it to have the settlements, probably Supreme Court the settlements will prevail. Despite the Supreme Court, whatever Supreme Court order will be there, because order has been issued by the Supreme Court to negotiate it.
Mr. Bagga?
I think it's a great opportunity for employers to have a constructive dialogue with the workmen or the unions, whichever may be the people, and also to get on the table the perspective of the employer and the perspective of the employees, and then try and put what are the likely solutions that can emerge from there, and continue a healthy debate. If you are in a position to open up your establishment to whatever extent, I think this may be an opportunity to get them engaged and to open it in a very viable and proper manner. If you are restricted to 30% employees, then you can figure out how to bring those 30% and by rotation, etc., etc. And I think by the time I do not foresee, unless the negotiation has started earlier, that the negotiation will finish by end of July. But yes, I think a good start should be made and a great understanding should appear in both the parties.
Great. Thank you, sir. Kaustubh, your final take?
I think over time, the only three possibilities are that the Supreme Court decides that the wages have to be paid for those 50-day periods, or they don't, and that the MH order was not valid in the first place. I think the safest option for both employers and employees right now is to go with the middle option of just settling and figuring out how we move forward and how we can continue to work and actually get the economy back on its tracks. I think there's no point waiting at this. Settlement would be the best option.
Kaustubh, I think this reminds me of during the cricket, one of the kind of cricket matches between India and England. Mr. Lala Amarnath was expert commentator, and he was asked, saying, "Sir, on a fourth day of the match, saying, sir, would you tell us what will happen here? What is your expert view?" So he said, India could win, England could win, or match could turn out to be draw. You were still qualified today to be an expert commentator. Thank you. Apurva, what's your take?
I think there are two, some relief for the employers, particularly by the clarity that we get now that it's really a 50-day time period that we are looking at, that the MHA order stands withdrawn from May 17. So there's some relief there, and also in the settlement mechanism. But I think, Suhas, will be having some more webinars on this subject in the future. There's some more to come.
There's already an epidemic of webinar now. Yeah. Thank you very much. Thanks a lot to everybody. Shiv Prasad ji,
thank you so much. Thank you so much, Suhas and the panelists, for this exciting webinar where you dissected the Supreme Court judgment, gave us the background. And you're right, there have been epidemics of webinars, but there's no epidemic act to control those webinars. So I'll hand over now to Kalnan for his last words.
Thank you very much, Shiv Prasad. Thank you, Suhas bhai and the entire respected panel for a very enriching and a practical, pragmatic view onto the judgment. First thing is, I really appreciate your value to the Medico staff that has been working tirelessly. Your presentations always starts with that slide, and I salute this approach. And I think the takeaway we all have is, with all the various judgments and circulars in the last 3 months, now the Supreme Court is also a mixed bag where there is a wait and watch, and also we come to July. But a good thing is that there is an open door left. Thank you, gentlemen, for this detailed study of the Supreme Court order for the benefit of our SICC members. Thank you very much, Shiv Prasad, for organizing this interesting subject and having Legasis team on board with this esteemed audience. Thank you very much, gentlemen. Please stay safe. Take care.
Thank you very much. Thanks a lot, Colonel Saab. What we will do.
My apologies, Suhas bhai. I just end my comments with one line that one thing I've always appreciated about the Legasis team is the business-like solutions on the way forward is always the end of a discussion. It doesn't end into a legal discussion, because businesses, the lawyers do enjoy discussing a lot about the provisions. But what I really appreciate, and I compliment Suhas bhai and the entire panel, that adding the realistic and the pragmatic touch is what the business leaders today on the call needed. So thanks for that touch always. Appreciate it.
Thank you very much. I think there are some questions which need answers, but I think because of paucity of time, we may not do it currently. We will reach out to the individuals who have raised those questions, and we will revert back. Mehak, I think we should all undertake to revert back with those questions.
Sure. Yeah.
Thank you, everybody. Thanks a lot. I think it's been a very engaging and learning experience for us. Uh, I hope that we will be coming out of the lockdown very soon. Everybody is geared up to go back to the work. Now we are seeing cases where uh, somebody known to you is COVID positive and has come out. Are more such stories coming out rather than saying there was somebody COVID positive and who was not returned back home? That's a very good sign, and that's why we're completely obliged and grateful to all the healthcare workers, all those frontliners, all those COVID warriors who are keeping us safe. I think hats off to them. Whatever possible manner we will be committed to helping them out. But in our own way, one help that we would do is we will not overwhelm the healthcare infrastructure because of acting stupidly. Thank you very much. Thanks a lot to everybody.
Very well.
Thank you. Thank you very much.
Thank you.
Thank you.
Bye, everyone. Thank you.
Bye.
Thank you.